Lisa and Jennifer. We're just delighted that you're able to join us this morning. I've been practicing financial planning for almost 40 years, so I've seen a few trusts in my day. And one of the things that people tend to think about when they look at trusts is it's a document, but it really isn't a document. It's a plan to help you help your family. And we think it's so important. We see all kinds of nuances and problems, and we're not lawyers. We can't fix those, but we can bring them to people's attention. I'm going to tell you one real brief story. This is a story of a friend of mine who is in the financial business, and he, unfortunately, his mom passed away. They'd done estate planning. She had a trust, and the assets passed directly down to him. He immediately put that in his bank account, and then started to think about how to invest the money. And unfortunately, he made a big mistake because he was married. He commingled the assets, and I'm sad to say, shortly thereafter, his wife filed for a divorce, and she took half of mom's money. He should have known better, but he didn't really think through it. And that's an easy solution for people like Lisa and Jennifer. And what we really want to do is make sure that your estate plan is just as rock solid as it can be. And we can't do that on our own, but we need the help of the experts. So with that, I'll turn it back to Brittany. And again, thank you not only to the panelists, but to the team and all of you for your support over the years. Thank you.
Great. Thank you, Troy. I'm just going to share my screen here. Pull up the presentation. So welcome to Estate Planning 101, the basics everyone should know. There we go. So I'm going to do a quick introduction of our speakers. We are so fortunate to have two expert estate attorneys with us today. They are the partners of Whiteston, Phillips, Samuth and Sinex. So we have Lisa Samuth, who for nearly 2 decades has served clients on estate and tax planning, including multi-generational estate plans, probate, trust, and administration matters. She has served as a member of the Estates and Trust Council of Rady's Children's Hospital since 2019 and volunteers for the San Diego County Bar Association's Will for Heroes program. Our other speaker is Jennifer Sinex, who has advised clients on estate planning, probate, trust administration, and estate and gift tax planning for over 25 years. She is a certified legal specialist in estate planning by the State Bar of California, a designation which is reserved for a very small percentage of attorneys, and she has been recognized as an AV preeminent rated attorney and a best lawyer for 2022 and 2023. So thank you both for being here.
Thank you. We appreciate that introduction, Brittany, and Troy and the whole team at Wealth Analytics. Thank you for having us join you today. Jennifer and I are very excited to talk about what we both do for a living, and we're very passionate about it. Eric Whiteston has been the founding partner for the firm, and Jennifer and I have worked with him for many years, and a little bit less than 2 years ago he approached us to take over ownership, and so we are the proud owners of a law firm. And it's been a wild ride. There's just a lot of exciting things that are happening here. We are lucky enough that Eric and Susan want to continue working with their clients, and so they still are practicing and advising clients, which is great for us. As we transition our new team, we're kind of following in their footsteps and adding in some younger associate attorneys. Hillary Kleinman is our special counsel, who is just a huge asset to us. Lindsay Baird, Carolina Facine, and Marissa Liebert all are our associate attorneys who really help us service our clients and do what we do best, is help them with their planning needs. And also when we have a loved one who passed away, helping with the trust administration. And just to kind of touch on the next slide, Brittany, the areas that we focus on at our firm really focus a lot on estate planning. And we also do some business and real estate transaction, and do a lot right now of probate and trust administration. And Jennifer, I don't know if you want to say a little bit about yourself and just the areas of practice as well too.
Lisa and I have complementary areas of practice. We both do estate planning and probate and trust administration and tax planning. We do very similar things to each other. Susan Phillips of our office and Eric Whiteson primarily do the business planning and compliance work. So it's a complementary practice area to ours. Lisa and I have known each other for, I mean, I don't even know, 15 years, 20 years now. We've worked together on and off, and she's a personal friend of mine and a neighbor of mine, and we work out together on Saturday mornings. So we're very intricately involved in each other's lives, and it's a privilege to work with her and to learn how to be a business owner at the same time just practicing our craft.
Yes, we're like the two hands that hold each other out. It's a really nice team, and we are very lucky to be where we are today.
Well, we're so fortunate to have you both, so we can jump on into our first question. So Jennifer, I'll ask this one to you. What documents make up a basic estate plan?
So as the slide says, a will, a trust, an advanced healthcare directive, and a financial power of attorney. And these documents are designed to memorialize your wishes and designate the people who will handle things if you become incapacitated and after you pass away. So they're very important documents. We're going to go into detail about each one of them in successive slides and successive questions. But these documents, if done properly, will keep your matter out of court. And that's one of the primary concerns that clients have. They hear nightmare stories about probate and conservatorship proceedings, which is the alternative to, if you have no estate planning, those are the proceedings that govern what happens when you are incapacitated and what happens after you pass away. And those are part of public record. So there's also a privacy component in getting these documents in place.
Thank you. So we'll move into our next question. This one's for Lisa. And we're kind of starting basic here, and then we'll dive into the nitty gritty and a little bit more complex. So Lisa, what is the difference between a will and a trust? And do I need a will if I have a trust? That's a very common question we hear.
Yeah, absolutely. But very common on our side for clients who are coming in for the first time. And what I will say about a will and a trust that are similar first is that they both allow the individuals who's creating the document to provide who gets to inherit when they pass away and who's going to be in charge of that as well. And so they both accomplish that goal. The vehicles for a will and a trust are different in the sense that a will is effective only the moment you pass away, where a trust is effective as soon as you sign it, and it's also effective upon death. So a trust will actually function for you when you are also incapacitated. One of the things that happens with a will, because it's only effective on death, is that it doesn't avoid the probate process. With having just a will in place and no other documents, you are actually having all of your assets in your individual name. And so if you pass away and you have the deed to your house in your name, you're not here to sign the deed over to whoever should be receiving that under your will. And so the probate process is started to get the court order to allow that to happen according to what your will says. And the individual in a will who handles that is called an executor. When we move over to a trust still is going to accomplish your wishes when you pass away, but the trust is functioning to avoid this court process. And so one of the most important things we work with clients on to educate them is trust funding. The deed to your house, once you create your trust, needs to be transferred into the trust. And unlike a will, you don't have an executor, but you have a very similar person or duty or job under a trust and as an executor, and that is called a trustee. And so if I created a trust today, I would serve as the trustee of my own trust, and I would transfer my house into the trust with me as a trustee as opposed to an individual. So when I pass away, I have inside of my trust document what are called successor trustees. And let's say I name Jennifer as my #1 top successor trustee because she knows everything about me and what I want. She would step into my shoes when I pass away, and then she would follow the terms of the trust to distribute assets out to my children according to how I want that set up. And those are really the biggest difference. It's whether you are trying to avoid the probate process or stay out of the, or if you are comfortable with the probate. And there's some rare situations why probate could be helpful in some proceedings, which is probably above the conversation we're going to talk today. But you will commonly hear clients say, well, if I do this trust and it plans for everything upon incapacity and death, why would I also need a will? And in that setting, the type of will we prepare that is unique to establishing a trust along with a will, it's called a pour-over will. And that will specifically says that the beneficiary is the trust. And so the goal is to accomplish with all of your assets that are inside the trust, and if anything is inadvertently not transferred to the trust, your will say, my trust is supposed to be the beneficiary. But in cases like that, we always like clients to know wills still do not avoid the probate process. And I know Jennifer is going to talk about that process in a little bit, but there's a threshold number for value of assets that triggers probate. So if you have assets in excess of $184,500, that's actually what triggers a probate. So I could have a trust that I created. I could transfer my house inside of the trust. And maybe I forgot to transfer this account that I inherited from my mom when it was distributed to me. It was just distributed to Lisa Samuth, and it has $200,000 in it, and I pass away. Jennifer's going to say, shoot, she's going to look to my will though, and my will is going to say my trust is the beneficiary, but there will have to be a probate for that account because it's over the probate threshold. And so those are some pretty important concepts to understand, and the audience can let us know if they have questions as a follow-up to any of that information.
That was a great explanation, and that kind of leads us into our next question for Jennifer. If you could walk us through the probate process and timeline, and how do I avoid probate? Why might I not want to go to probate?
Well, in addition to having a trust and titling your assets in the trust, assets that have a beneficiary designation also avoid probate. So do assets that are jointly titled. So if you have a joint tenancy house, for example, or another person on your bank account, that avoids probate. It's not really estate planning though, because what happens on that second death is a probate. So it's better to have a trust and fund a trust. But just to be clear, some assets are not subject to probate because they pass by operation of law, because they're jointly titled or there's a beneficiary designation. But when a client comes to us and says, here's this bank account, it was left outside of my trust, or I never had a trust, this person never had a trust, then we know that we have to start a probate proceeding. Why? Because the bank will not turn the funds over. So it's really a function of how do you marshal or gather the assets. And clients know when they come to us with that problem that there's basically no way out. If the amount in that account or the aggregate of amounts in all accounts that are individually titled are less than the $184,500, there is a small estate affidavit process that also avoids probate. And that's a very simple process. We do a lot of administration, so we always look for the least complicated, least expensive solution. But sometimes you're just stuck with a probate. I personally like probates because it's very orderly. There are no secrets. Everything gets done. But clients don't like it because it's more expensive and it can take longer than a trust administration. Larger estates take a long time to administer because we might have an estate tax return due or other issues that are involved in a more complicated estate. But with a probate, you can guarantee you're going to be in that probate proceeding for up to and usually in excess of 1 year. So we gather the information from the client, and there are very specific forms that have to be filed with the court. It's a very specific set of judicial counsel forms. Some people say, can I do it myself? You can, but you just run into roadblock after roadblock after roadblock getting it through the court system. So we help the client fill out the petition for probate, and they sign it and we file it. And then we have to give notice to everybody who, if it's a pour over will, we have to give notice to all the trust beneficiaries and any heirs at law under a California probate code section. Heirs at law are next of kin if you had died with no estate planning. Usually it's your children, your parents, sometimes it's your siblings, sometimes it's your nieces and nephews. It depends on who you have surviving you. So we have to give notice, and we have to publish a notice that a probate has begun. And then after that happens, we have a court hearing. That court hearing can be set 6 weeks or sometimes 4 or 5 months out. So there is some delay there as well. Our court system is one of the largest impacted probate court calendars in the nation, especially based on our geographical area. They closed down our North County Vista probate court, and we only have 3 probate judges. And they're all 3 relatively new to probate as well. One used to be a probate attorney, so she has a lot more familiarity, but their calendars are impacted. And then you're getting in front of judges who may or may not have a lot of probate experience. So you have to make sure that that all of the I's are dotted and T's are crossed. So we have that first hearing. The court is going to appoint, assuming we've properly submitted our documentation, they're going to appoint that executor or administrator. It's called an administrator if that person had no will. And then we have to send notice to creditors, and they have 4 months to come back and file a creditor claim, or they're forever barred. So we send creditor claims to every creditor, because surprisingly, some do not submit a creditor claim. When they do submit a creditor claim, we have our personal representative, your executor or administrator, approve or not approve the creditor claim, depending on whether it's valid. Anyway, that process goes along. We're waiting for creditors to file their claims. We're approving or not approving them. You can, during that process, petition after 4 months to get a preliminary distribution of assets out. Rarely do we do that. We try to just push through the probate as fast as we can and get a final decree of distribution so that we can move the assets out of the probate. But during that process, it could be held up by if there's a requirement to file an estate tax return, which we'll talk about that requirement a little bit later, or other things may hold up closing that probate. But we try very hard to, as quickly as possible, get the creditor claims out. And then we have to inventory the assets. So we gather information on the assets that are part of the probate. We submit them to a person called a California probate referee. That's a person who is a court-appointed appraiser. And they submit a value, which usually we have no problems with that. You can dispute the value if you think it's too low or too high. And that gets filed with the court. Once the creditor claim period is over, the 4 months after sending notice to creditors, and once the inventory and appraisal has been filed, you can then petition the court to close the probate if all taxes have been paid and the debts have been handled. But you file another petition to do that, and you have to wait for the court calendar. So it's very rare that we can finish a probate in 1 year just because of the probate court calendar. And again, all of this is public record. So if your nosy uncle wants to come and read that probate file and see what assets there were, they can do that. Similarly, when we petition to appoint that personal representative, if somebody wants to contest the will, if there's a will, they can come forth and do that as well. So, you're kind of getting out in front of it. So it's very clear at the end of that process who gets what, and that it's been done in an orderly fashion. But the probate fees are high. It's a percentage of the assets. So just briefly, it's 4% of the first 100,000, 3% of the next 100,000, and 2% of the next 800,000. And then it goes on after that. So for $1 million probate, the attorney's fees are $23,000. The executor or administrator is also entitled to the same amount, $23,000. So it's clearly, generally speaking, more expensive to probate an asset than it is to have a trust administration of an asset.
And if you haven't picked up on this, I call Jennifer Mother of Probate. She is an expert in this area. This is the area where I think you started practicing initially. So your foundation comes to this very rule-intensive process, and it really is a guideline for our trust administrations, but we don't have to follow all these court rules and these timelines. We get to move along with the clients, and it tends to be a less onerous situation. And it's not to say that trust administration doesn't have cost associated with it, but it's based on the time and the hours involved in that trust administration, as opposed to what is the value of the assets that we're managing. It feels a little bit more appropriate in regards to the expense and the cost of administering a estate. And I do wanted to say, and Jennifer talked about the initial petition and the time of getting a hearing scheduled for just opening a probate process. When that final petition to request the probate to be closed, that petition, the calendar for it is more jammed up. And so it can take a much longer. Do you guys have an idea of the average time span you're looking at right now? Is it?
Well, it's interesting because, like I said, there are 3 different judges. And so we just filed something to be heard in Judge Alvarez's courtroom, and we got like a late October date, which is a very fast date. It's not surprising right now to file things that are not going to be heard until January. One thing I forgot to talk about, but I'll just briefly touch on it, is there is a requirement in a probate process to render an accounting, meaning the account statements that show what you've done with the assets from the time the probate started until it ends needs to be submitted to the court unless the heirs or beneficiaries waive that accounting. So that accounting calendar, because those have a bigger review process by the court staff, that one is set further out for sure. I think on waiver of accounting, it depends on the department, and it depends on, it just depends on the court calendar. You can maybe close them faster with a waiver of accounting, but you don't have any control over whether the beneficiaries or heirs will waive that accounting. They have a right to it if they want to see one.
Well, thank you for explaining the probate process. Seems like quite a timely process, and like you said, kind of high fees too, and dealing with a lot of those factors. So next question, I'll go back to you, Lisa. Who needs a trust, and what assets can and cannot go into a trust?
So if Jennifer's explanation wasn't motivating enough for why they want a trust, that is the number one reason, is to stay out of that court process. But people who would really want to be focused on having a trust has somewhat to do with the value of your assets. So if you're renting and you have a modest income, and you have maybe $100,000 in the bank account, you don't necessarily need a trust, because what you have is not going to be exposed to a probate process. And so a simple will may work appropriately for you. When you're over this threshold of $184,500 for your cumulative assets from a gross value. So if you bought a house for $500,000 and put $100,000 down, and so you only have $100,000 worth of equity, the fact that the house is worth $500,000, it's going to actually trigger the probate. So one of my questions when I'm just generally talking to a client is, I do like to find out if they own their home, because that tells me financially they absolutely should have a trust if they're trying to avoid the probate process. I have had some clients who are in situations where they don't own real estate, but they have a large life insurance policy because they have a couple of minor children, and they're also building their retirement account. Both of those assets, and I know this is talked about a little bit later on, those are considered non-probate assets, because you can designate beneficiaries of a life insurance policy or a retirement account. But if you have minor children, if you designate them as the beneficiary on a life insurance policy, they're not going to be able to accept those proceeds if they're under 18 years of age. And that triggers and actually a proceeding called a guardianship of the estate, regardless if one parent has passed away and the other parent is living. So I've actually had to open up guardianship proceedings for the biological parent who's surviving, because life insurance proceeds were designated to a minor, for example. And so that would be a reason alone just to be able to have a trust, is to make sure you're not triggering a court proceeding where the court's going to be overseeing the money for your minor children. And they, in a guardianship proceeding, those children get all of the money at 18, which I know that if you have any type of money, an 18-year-old should not have that all at once. It does things to them. It makes them take paths and think differently. So it's to protect their interest overall. But avoiding probate and having minor children, those are really the big reasons to have a trust. And there's some estate tax reasons as well too, which is more on the advanced planning side, but those are the reasons I think they're best to communicate today.
Perfect. Thank you. And Jennifer, if you could just briefly go over, what the role of a trustee is, how you might go about choosing a successor trustee, and why someone might hire a professional trustee.
Sure. The trustor and the trustee are the same when you just first form your trust. You are the person forming your trust. You are acting as your own trustee. If you're husband and wife, you're both co-trustees. So that's pretty straightforward. When you're choosing your successor trustee, you want to choose somebody who is fiscally responsible and will follow the rules of a trust administration, because there are probate code sections that govern what you have to do to administer a trust. So there are some things to do after a person passes away with a trust. And then you have some fiduciary duties to account to the beneficiaries and manage the assets properly and allocate those assets in investments that are appropriate for the beneficiaries that are in that trust. So if you have minors, it needs to be diversified and planned for on the financial planning side, that for appropriate ages of those minors, or if it's an elderly person. So you just have to be very careful about who you choose as trustee, because they need to be up to the task. It is a somewhat thankless job in this way. They have a huge amount of liability if they don't do things properly, and you can provide for compensation to trustees in the trust document, but it's ordinary income to them, and the amount of work involved is a lot of work if you already, for example, have a full-time job. So it's okay to designate a family member as your trustee if they're the trusted family member. And that person might be different from the person you designate as the agent under your healthcare directive. Maybe your sister is better with those types of issues. Maybe she has some medical expertise, but maybe she's too busy to be a trustee, or maybe she is not so great with money. So you can have different people acting in those roles. As far as using a private professional fiduciary or corporate trustee, those are great choices. They do have their own fee schedules, but they have a couple of things going for them. It probably will cost more than an individual trustee. They do, though, have their own errors and omissions policies. So if somebody does something wrong, there is a compensation fund available for that, for lack of better words. They also have usually some expertise in managing estates, and obviously they have the time to do it because that's what they do professionally. Corporate trustees usually require a minimum asset amount before they'll manage it, and usually it's a minimum investable amount. So if you just have 5 pieces of real property and no liquidity, a corporate trustee may or may not be willing, if you don't plan to sell, to act. So that's something to keep in mind as well when you're trying to choose. If you're choosing a professional trustee, private professional fiduciary, we encourage people to go and interview the fiduciary firms around town that we suggest, so they can get to know these people, because if you're a younger couple, the people that you're meeting with now may or may not be acting as professional fiduciaries at the time that you pass away if you live a normal lifespan. But most of the sort of larger developed firms that do that kind of work have their own young people and sort of a succession plan in place. So it is an appropriate choice, but we do recommend that you get to know the people who will be acting if you're going to get a private professional fiduciary, and also with the corporate trustee shops that are out there. But we've had great experiences with a lot of them. It's not, we don't dissuade people from making that choice. If they want it, make that choice.
Thank you.
With professionals, they're efficient too. I mean, because they've done it over and over, they know what needs to be done. So there's always advantages for that circumstance as well. I actually had some clients who wanted to name a private professional fiduciary who was what we would call a solo practitioner. And then the concern for me as a planning attorney, because I'm always talking about what if scenarios, is what if that person retires or is no longer with us? And so for that particular situation, they ended up naming a institution just in case. And then that's just a nice mechanism in the design of your estate planning documents when you're thinking about all of these what ifs. But reviewing your trust every 2, 3, no more than 5 years is a really good thing to do, especially just kind of looking at who your key players are and what you want and how things may have changed for you.
Thank you. That kind of leads us into our next question, and we have a question from the audience as well. So I'll kind of combine these. We are wondering, how often should you review your trust? What might trigger the need for updates? And our audience, is from all over California, but many other states as well. So we have someone who's wondering, if you no longer live in the state where you created your will and or your trust, does it need to be refiled in the new state?
So yeah, I'll take that. You absolutely should. So the laws that Jennifer and I are talking about from a probate standpoint are all governed by the state of California. So if you become a resident of another state, it is very important for you to meet with an attorney in that area to review what you have done. And if you're moving from a community property state to what we call separate property states, there are different treatments of your estate planning process. So there are some significant differences. And a very important thing to do within, a year or two after you moved. It's not to say, I mean, I definitely have had clients that don't notify me that they have moved out of state myself, because if they let us know as a firm that they're moving out of state, we will recommend that to them directly so they know. But years ago, I was notified of a client of mine who moved to Arizona. And he was a resident of Arizona. He still owned real estate here. The beneficiaries were still here. But in that situation, we actually had a trust administration in California, following all California rules, and also a trust administration in Arizona, because that was the only way to handle it appropriately. So it kind of created double the work as well. So it is a savings when you are no longer here to get everything consolidated, even though there is a cost associated always with updating your estate plan.
Mm-hmm. And I think we just got another question that kind of goes along with this. Does the firm that created your trust need to make any / all changes to your trust, or can any firm update your trust?
Yeah, any estate planning attorney can make updates to your trust. So let's say you move from here to Merced. You can certainly get your own estate planning attorney up there. Now life is much easier in that regard, in that we can do Teams meetings and Zoom meetings, and we can have clients that live all over the place. But if you're more comfortable having an attorney closer to where you are, that's perfectly appropriate to have another attorney amend your trust.
Perfect. Thank you for that. So Jennifer, I'll turn this next one over to you. How can a trust give you control over distributions to your heirs?
Well, like Lisa pointed out, if you have a probate and you have no will in place, or even if you have a will in place, beneficiaries will receive their inheritance from that probate at age 18. There might be a guardianship for minors until age 18, but generally speaking, kids will get the money at age 18. If you have a will that creates a testamentary trust, you can actually build a trust into a will. Sometimes people do that because they don't really have a lot of assets and they just want a will, but in case something happened to their child and their grandchildren are going to inherit, they can create a testamentary trust that will keep that money in the trust for longer than age 18, but that will still has to be probated. So the point is, with a trust, you can create the ages and stages at which any beneficiary receives their inheritance, not just minors, but you may have a child with a disability and you may need special needs trust provisions. Maybe they're an adult child and they receive public benefits, and you don't want to disqualify them from their public benefits with your inheritance money. There are specialized trusts that can hold that money and make payments to them in a way that does not disqualify them from public benefits. And similarly, if you have a child that may have I hate to be blunt about it, but this is what we do, a gambling problem, a drug addiction, you can create trusts that prevent them from harming themselves with a large amount of money that they may receive. So trusts can do amazing things. They can also do some tax planning. So you can skip generations and save some tax in that way. That's a complicated discussion. It's probably would be a separate presentation, but trusts provide a huge amount of flexibility in the way in which the beneficiaries receive their assets that can save tax and certainly provide the level of control that you as the testate or the creator of the trust want in place.
I just recently created for a client, and I haven't had this particular situation come up, where she didn't want to leave one of her children inheritance outright because he would give it away. He just is so sympathetic to everybody else's plight. He, is very comfortable with what he does for a living, just very minimal. I think he lives like in Oklahoma, somewhere outside of, the Southern California expenses of the cost of living. But he would just give it to other people. And so everything's being held and we've designed it very generously for the trustee to be able to give him money as the trustee deems appropriate to make sure if he wants to buy a house, the money is there for them. So there's a specific instruction that if he would like to be a homeowner, the trust can buy that for him. And so it's a great, the trust provide the ability to protect your kids from themselves, and also in the event of a divorce. And if you have a child who has married someone who is an in-law that you have grown to not love and adore, in that, in a unfortunate situation like that, you can also protect your child from that type of situation as well under a trust.
Well, there's also another fun thing that we get to do once in a while is pet trust. So if you have a macaw or a tortoise, or you're elderly and you know your animal will outlive you, we can create trusts that take care of that animal for their lifetime. And that's a really fun planning. For me, I love that kind of thing.
I actually haven't done one in years, so if anybody needs one.
Please bring us your pet trust and bring your pet to the meeting.
So we actually had a question, Lisa, that was, kind of about what you were saying, how to shield assets that will be passed to your kids from your kids' spouses in the event, they get a divorce or something like that. So they were wondering if you could explain some of the benefits and limitations of designating your kids under a separate property trust.
Yeah, so if you're setting up your estate plan and you have a child that you are trying to protect from those types of situations, you would design, or I would suggest designing something to the effect that says it's held in trust for their lifetime. And then the trustee who's going to be in charge of that, it would naturally not make sense to make that same child, because they would be self-trusteeing and then could do whatever they want. You would want to name somebody who would have the ability to say no, and really follow the terms that are designed. And so that's a careful planning process for every client's specific situation with their child that they are concerned about in that sense. And so sometimes we draft that very limited, depending on the circumstances. And sometimes we wanted to have a little bit more flexibility for that purpose. But while it stays in upon the death of the parent who leaves the trust for their child in for their lifetime, it's an irrevocable trust upon the death of the parent. And that irrevocability is what protects them in a divorce proceeding. That will always be maintained as what we call their separate assets. And truly the idea of irrevocable trust is no individual really owns the assets that are inside of that trust. And that is the way that it's not included in a split for divorce. That will be maintained with the trustee of the trust, and they continue to use the money for things like health, education, maintenance, and support. And then we may add some other provisions in there depending on the circumstances of what the parent wants to make available for that child.
Excellent. Thank you for explaining that. So we have a couple questions about how can I incorporate charitable giving or philanthropy into my estate? And I know we had a specific question about, the pros and cons of setting up a foundation versus using a trust that passes assets to charity. So maybe Jennifer, if you wouldn't mind speaking about that.
Right. So it's common for us to draft trusts where a charity is a beneficiary. And that would just be usually a cash gift, an outright gift, or a share of the trust after the trust administration has completed. That's a great thing for reducing estate tax, for example. But that's something that happens on death. You can set up charitable remainder trusts where you can make lifetime gifts to these trusts, and you can even receive income from them, and then the remainder goes to the charity. There are a lot of different charitable planning techniques that are great, and they can really help somebody out from a tax perspective, or if they're just charitably inclined. It's a lot of the plan giving departments will do that planning for the client. If they know that, for example, UCSD or Scripps is the recipient, they don't draft the documents, but they'll design the gift with some software that will tell the client what the charitable deduction would be to them, and the different techniques that are available based on the types of assets they want to gift. And then usually the entity, the plan giving department will have an attorney do the drafting. So we're drafting some charitable trusts right now for some plan giving departments, and it's something that we really enjoy doing. Like I said, it is a deduction on the estate tax return, so there can be some pretty creative planning if you don't want your estate tax to be entirely paid to the IRS and would like to have some deductions. Charitable planning is great for that as well. So you can do the charitable giving as a lifetime gift, or you can do it as a testamentary or death gift as well.
Awesome. Thank you for that. And our next question is, how does living in a community property state change your trust?
Yeah, I mean, how many community property states are there? 9? I think it's 9 total. California is one of them. So all those other states are what are known as common law or separate property states. And we get clients, husband and wives in particular, that will come from New York or New Jersey. And each of them will come to us and they will have a his trust and a her trust, because that's what happens in non-community property states. And it's not to say in a community property state you won't see that, but we have in a community property state, husband and wives can create joint trusts for their joint community assets. They may have separate property themselves. So I have designed estate plans where I have an ours trust, a his trust, and a hers trust. And that gets a little bit more on the advanced planning side of things, but there is a significant difference in the treatment from a state law perspective, and even some tax laws as well, when we compare these community property states to separate property states.
Mm-hmm.
I'm sorry, I didn't answer the question about foundations. I just realized.
Yeah.
You can set up a family foundation, and it's a little bit complex, but our office has done some of that planning. A family foundation, you can actually employ family members. It's quite an involved process, but if it's done per the rules, if it's done properly and structured properly, it facilitates gifts during lifetime. And you make, gifts to the family foundation, and then the family foundation carries out its purpose. If you're not a person who wants to set up a family foundation, you can set up a donor advised fund. So that's a really easy and flexible way for you to make either lifetime or death time gifts. And you can designate who is going to direct where those gifts go. So I can set up a donor advised fund. I can put $10,000 in it, or 100,000 or $1 million or higher amount. And then I can designate my child as the adult child as the person who's going to say, okay, I'm going to say, I want this for the purpose of, health and underprivileged communities. And then that child can direct to what organizations those gifts are made.
I have right now 2 children whose parents set up a donor advised fund and with a local organization, and they both, with the donor advised fund that this mother had set up, she had essentially directed money that's going to be funneled into it to go out to charities, but she also segued that each of her daughters would get their own donor advised funds created from that. And so they have the ability now to kind of manage this charitable aspect of their worlds and make decisions as just part of her legacy of carrying good in the world. And they both think it's just such a really a neat thing. They're inheriting, but then they also have this inheritance that they are going to be over many, many years sharing that with charities of their choice as well too. It's pretty dynamic.
I wanted to say one other thing about the community property. This is something that Lisa and I deal with all the time. In separate property states, if husband dies, there's a step up in basis to the value as of his date of death of his assets. In a community property state, for community property assets, you get a step up in basis on both halves of the community property. Why is that important? It's related to capital gains treatment. So if I have a lot of stock and my husband and I bought it however long ago, and there's all this built-in capital gain, you'll see it on the statements, this unrealized gain. That goes away if that's community property, and all of that gets a step up in basis. It becomes the fair market value on the date of death. Occasionally it's a step down in basis, but usually it's a step up, especially if you've held something for a long time. For example, real estate. If my husband and I buy a house and I die, my husband is going to get the fair market value as of my date of death as the new basis for that house. So he can go ahead and sell it and not recognize capital gain and maybe move to a different house. So it's a real benefit. It's such a great benefit.
Yeah, and even if you have rental properties as a husband and wife and you've been depreciating that over years, so
Yes.
what we call your cost basis becomes almost zero.
Right.
It resets for the surviving spouse if it's community property, which is huge. It's a
Yeah.
great tax benefit.
It works as well if you have an entity, like a partnership. And maybe you've got some buildings that have been sitting there and you've got this very low basis in those buildings, mainly from depreciation, or they've been held a long time. It works for that as well.
And speaking about tax benefits or not, our next question is, how will future tax laws change the trust landscape? So I'll send this over to you, Lisa.
We got a big change coming for us, actually.
Yes,
So, from our legislative history, if I always explain it to clients, in the 90s, the estate tax exemption, which is also known as a death tax, it ranged from 600,000 to 675, and it's been increasing ever since. But in the 90s, if you passed away and you owned $1 million and your estate tax exemption at that time was 600,000, you had $400,000 in excess, and the tax used to be 55% on that excess. So there was a lot of planning in our estate planning world to help maximize both a husband and a wife's estate tax exemption at first and second death. But as time has gone on, that number has increased. In 2009, it reached 3.5 million. In 2011, there was a sunset provision, which is similar to the one we are looking at right now for 2026. But the sunset provision back in 2011 said that if the legislature didn't make any changes or couldn't make a decision, that the estate tax exemption that was set at 3.5 million was going to drop back down to $1 million. That did not happen. In 2011, they ended up in mid-January deciding. So January 1, no one really knew what was going to happen. But in mid-January of 2011, they set the exemption at 5 million and did some new provisions with the estate tax. It's indexed for inflation now, and also something called portability, which is a big topic of conversation when we're talking with husband and wives or at the death of a first spouse, because there's a time period to take advantage of portability or it can go away. The number has been continuing to increase. In 2018, I call it the double down legislation. They took that $5 million and made it 10 million, and in adjusting it for inflation, it ended up being 11.18 million in 2018, and it's continuing to increase. Right now, this year, for anyone who passes away, they have a $12.92 million exemption, so almost 13 million. We're going to see that go over 13 million next year. That number can be reduced if you've made any lifetime taxable gifts. So gifting is interrelated with that number as well. So that's also an important concept. But the sunset provision that's headed our way is due on January 1 of 2026. And what that law says right now, again, if the legislature doesn't make any changes, the estate tax exemption is set to reset at $5 million to look like what it did in 2011, but it will also be adjusted for inflation. And I've heard those inflation numbers, Jennifer, anywhere from 6.5 to 7 million is what that number may look like. But dropping from 13 million to practically half, that will be the first time in history that it's gone down. So there's a lot of controversy of whether it will happen. But if nothing's done or nothing can be decided differently, it will happen. And I think we could potentially be in a legislative environment where decisions are hard to agree on. And I'll leave it at that. So it's a great time to review your trusts, even if you've had them created. If you have anything that was created before 2018, it's really good to review them. I have a lot of clients who are reviewing right now, and we're talking about, in a couple of years, depending on where they are right now, how important it will be for them to check in 2026, if they're kind of in a borderline situation, or just moving forward with a totally different design for tax purposes because of where they're at and their age, and looking at all of those factors. And, when we work with our clients who have wealth advisors who are able to help us project what clients' net worth is going to look like in 3, 5, 10 years, like Wealth Analytics can do for clients. It's a tremendous value to the client because we're not able to project those. I mean, that's truly what Wealth Analytics does, is it's to look at your future and how to make this grow and work the best for you. And so that type of just forecasting is essential when we're looking at these tax laws changing, because we can't control it, and we just get what we get and plan around it.
And that's exactly, why we have you guys on. It's a collaborative strategy between, the both of us, and we, work closely with our clients, attorneys, CPAs, estate attorneys in that way. So perfect. And Jennifer, I'll pass this next one over to you. I wanted to touch on what is a financial power of attorney, and then we could kind of move into also advanced healthcare directives as well.
Okay, sure. A financial power of attorney is critically important because we always think about estate planning as planning the transfer of our assets after we die, but often people get sick, or they have dementia, or they lose capacity for a temporary period of time due to an accident or an injury. The financial power of attorney document is the document that designates who will manage your finances while you're incapacitated. It is for those assets. If you do have a trust, it's for those assets that are outside of your trust. You might think, well, what would I leave outside of my trust? Retirement accounts are outside of your trust. Life insurance is outside of your trust. If you have any kind of an asset that is outside of your trust, there will be no one to take care of it. Also, clients often will leave a primary checking account outside of their trust after they get a trust established, because they don't want to have to change all of their automatic deposits and debits out of there. So you may have things hanging out there outside of your trust that need to be dealt with while you're incapacitated. You need somebody to be able to sign your tax return when you're incapacitated. You may never need your power of attorney document, but it's there as a safety net in case you do. You want to have control over who comes in and takes care of that. Otherwise, with no financial power of attorney document in place, if there's an asset hanging out there that is not in your trust, the bank won't let anyone access it unless you file for a conservatorship of the estate to get yourself appointed and also to manage those assets. That's a court supervised process with accounting requirements and often a bond requirement that's payable from your assets. It's important too, because you want to be the person who designates that. If there's a conservatorship of the estate, there's a statute that governs who has priority of appointment. And that may not align with the people best suited to manage your assets. So for example, the priority of appointment would be your spouse. That might be appropriate. It might be your mom or your dad. Well, maybe your mom or your dad is somebody who doesn't manage money well, or they're incredibly elderly, or they're sick and battling something themselves. So you don't want that court process to take over what you could easily plan for. Those documents can authorize, if you want, they can authorize your attorney in fact, as it's called, your agent, to make gifts of your assets. If you have a pattern of gifting and you want to continue that, you give to your grandkids every year, or you give to a specific charity or charities, it will allow the continuance of that. It's just a really flexible tool, but it has to be in place or else a conservatorship happens.
I had a circumstance where we did planning for a client, and the son had contacted us, and I was working with him, and part of his father's, a major part of his father's income was coming in through leases he had for airplane hangars, and all of those leases were in his father's individual name. And we were able to use our power of attorney to negotiate and renew the leases to keep all of that income flowing to take care of all of his healthcare expenses. So it is really a safety net for these contingent assets that are out there.
Great, thank you. And we have a question that just came in. So are retirement accounts supposed to be outside of the trust? I think you mentioned that a little bit earlier.
Yeah, so the rules for retirement accounts, they actually require individuals to be the owner on title. So if anybody ever told you to change title, that's considered a change of ownership and would trigger all of the income tax to be due at that moment in a lump sum amount. So that is very alarming. You would not want to do that. So retirement accounts are traditionally they're the number one asset you're never going to retitle in your trust, but it is considered a non-probate asset because you can designate beneficiaries to receive those upon your passing. And that may be a charity. If a charity receives the assets from a retirement account directly, the charity doesn't have to pay income taxes. So I've had clients who come in who have won a trust, they have a huge and charitable intent. I wouldn't want to design the trust from an income tax perspective to have the client name the trust as a beneficiary and name all the charities in the trust. A better world for maximizing planning would be, who are the individuals that should inherit the trust assets, and let's designate the charities directly as beneficiaries on those retirement accounts, because now you've maximized a lot of your non-retirement assets to leave to individuals who don't have that benefit. So there's some creative things that can be done there, but retirement accounts, those are transferred at death by those beneficiary designations. And we have seen people not have beneficiaries designated, and that triggers a probate. So important to review, even if you think you did it. It's always a good time to check when you're doing a review, just double check everything.
And if you have minor or disabled beneficiaries, you can name the trust as the beneficiary of the IRA so that it will flow in there and be managed according to the trust terms. So we counsel clients on what's the appropriate way to designate your beneficiaries of an IRA or life insurance.
And that's something we do too. You know, we're constantly checking when we get retirement, you know, IRAs, Roth coming in, that there is a beneficiary. If not, we update the beneficiary. And like you said, some people have the trust, other people, it makes more sense to have an individual or a charity. So that's a good reminder for everyone to check. And if you're in the audience and not sure, you can email us and we can let you know what your beneficiaries are too. And it's simple to update at any time. So if you change your mind and want to change that. All right, so I think we got through all of our questions, and in respect of your time, I'll wrap it up here. So thank you so much, Lisa and Jennifer, for being with us today. Your knowledge is just so valuable to us, and I know to all of the attendees. I will be sending out a recording of this presentation along with the slides to anyone who attended. And I have a whole list of people who would like it as well. So I'll be sending that out. If we didn't get to your question today, or you'd like to talk through these topics deeper, feel free to give us a call or send us an email, and we're happy to do that. And I will go ahead and just put up on my screen Lisa and Jennifer's place of business. So for anyone who is interested, and you can also reach out to us as well. And we're happy to get you connected if you would like.
Thank you so much,
Thank
Brittany.
you. Thank you for the opportunity.
Thank you so much. We greatly appreciate it. And thank you everybody for being here today. And we are here as a resource if you need us. Thanks, everybody.
Thank you.
Have a great day.
Thank you.